So today we have Dixie McCollum, who is an attorney at our law firm of Richardson Thomas. And Dixie and I'm Brendan Green. We just recently went to trial, and Dixie and I prepared for that trial and tried that case on behalf of our clients in front of 12 random people that they didn't know.
That's correct.
We just kind of wanted to talk to everybody a little bit about the process, what you thought of it, what your favorite parts were, what the most difficult parts were, and how we get ready to represent our clients.
Absolutely. Well, Brendan, as you know, this was my first trial, so it was very eye-opening. I think I've learned several things that I would do maybe differently, but I've also learned that there's nothing quite like just being overly prepared. And I think if you are overly prepared, there's no way you can do a bad job. And I think we did a really good job of preparing for this case. I did the opening, you did the closing. I think from start to finish, we did a really good job and got a great outcome for our clients.
Yeah, I think you actually hit the nail on the head there about being prepared. It's so important that you know as much as you can about the case, because as you saw, things happen that you don't expect. You could tell the audience a little bit about the beginning of the case. The judge rules on what's going to come in.
Right. And I think one of the most interesting parts about trial, right, is that your client wants to know exactly what the game plan is going to be. And I think as a trial attorney, you really cannot have a set game plan because, like you just said, right, you don't know how the judge is going to rule on certain things. So
Yeah.
you really have to be very strategic. And I think it was nice to be a young attorney learning from you. I mean, I know you have trial experience, but you think on your feet very quickly. And I think that was a good learning point for me and how to do that very quickly from jury selection and onward. And I think even as much as arguing those motions the first day,
Yeah.
Everything comes down to the wire when it comes to that. I mean, if you win or lose those motions, it really dictates how trial is going to go. Now, granted, you don't know the outcome of those motions until the day before the trial. So you really have to know and pursue every different avenue that's there. I mean, truly.
Or sometimes even the morning of the trial, depending on what case it is. We got a little lucky with this case that we argued the pretrial motions the day before, but we had talked about that there was one motion that the judge could allow in certain evidence that made the defendant seem like a very nice and vulnerable man, and we did not think that evidence was going to come in.
Absolutely.
And we had kind of bet on the fact that it was probably an 80% chance the judge would not let it in. Well, the first thing we hear is that not only did the judge let it in, the judge told the jury about this man.
Yeah. Yeah, and I think that, to your point, Brendan, that is why it's so important also to be malleable in your opening and closing, right? I mean, if you memorize something completely, you really can't do that. I mean, you have to. I mean, to me, my opening was dictated by how the judge ruled, right? Like certain things that you would say are going to come in or not. I mean, you would need to know how the judge is going to rule and how you're going to, you're telling a story. So you're telling the jury who they don't know this case from Adam, but you do. We've spent the past couple months, a couple years working on it.
Yeah.
So I mean, it's really all about telling the story. How do you frame it? Well, we don't know how we're going to frame it until we know how the judge is going to rule.
Yep.
Which is why I think it's really important. It can be nerve-wracking for sure, but to think on your feet quickly and be a good advocate for your client.
Yeah.
So.
Being flexible and trying to learn not how to spin, but how something that you would not think is good for you is actually a positive for your case.
Yes.
And there's a great book out there called Don't Eat the Bruises, which is by an old trial attorney, Keith Mitnick, and lots of people who watch this probably know that. But that's essentially what that book is about is, hey, just because there's this bruise on the case, there's this defendant who can come off as a very nice guy, and they're going to allow this character evidence in. How do we spin that, or how do we use that to further tell our case and help our client? So I thought you did a great job of that, and being flexible is just so important throughout the case. Another thing that I wanted to touch on a little bit was jury selection.
Absolutely.
And there's a big push in our state, South Carolina. We do not have attorney-led voir dire, as you know, Dixie. And
Yes.
so
Yes.
we don't get to actually ask the jurors questions about their background and their life and how they feel about lawsuits and what they may think about this case. What we did is we submit a very few questions to the judge, and then the judge asks the jury. So why don't you walk us through and walk the people listening to this through a little bit about jury selection, why it's important, and what you thought of it.
Sure. Well, I will say, learning curve for a young attorney who did their first trial is that you can never overestimate how important voir dire is. And, obviously with our firm, our policy is to get the jury list, and then it's an all hands on deck effort from everyone in the firm to collect as much information as they can about 500 people who may be potential jurors. So you need to know how old they are, where they live, what are their political views, what do they do in their free time, what is their occupation. All of that will be very, very important because they could be one of those 12 people that ultimately gets to sit on your jury. And so we make an effort, as you know, to create a binder of every single juror and collect as much information as we can and to review that binder prior to trial, which again I think feeds back into the importance of preparation. You can never be too prepared. However, I was unprepared to know how quickly the judge may move on voir dire, because again, it is not conducted by us and it is conducted by the judge. And I think we got, maybe 4 minutes to decide who we were going to strike and who to have on our jury.
Yeah.
And I did not realize it was going to be that quick. And so it was nice having someone a bit more experienced. But at the end of the day, I definitely know for future trials to I think put even more preparation into a voir dire, because again those 12 jurors will decide your case, and I think any bias that they may have is really, really important to your client.
Yeah, and we all have biases, and I think that's one of the things as lawyers, and we've been working with our judiciary to help them understand that our own backgrounds, our own beliefs, our own experiences all flavor how we look at issues and how we look at a case, and every juror has their own background and their own opinions that comes in, and so for us to be able to try to determine how they may view something on a very small amount of information, such as where they live, what their house looks like, their job, their employment, their income, it's not a lot of information, and it's not the best system.
Well, and even
but that's what we have right now.
Absolutely. Even down to the questions that we ask them, right? I mean, how are they going to answer those questions? And I will say this may be a bit off topic, Brendan, but when I was in law school, I worked a summer out in Wyoming, and I was able to participate in a criminal trial.
Yes.
Where there in Wyoming, it was attorney conducted voir dire. And I love when it is attorney conducted, because you get to turn around and look at your jury and see how they answer questions. I think that that's super important to be an attorney and look at this audience. Who do I want to be on the jury? I think that, that's very, very important. And I think here, as you know, we were facing the judge, but the jury was actually, or the potential jurors were sitting behind us.
Yep.
And we weren't really able to turn around and really look at them as we were sitting and they were behind us, and the judge would ask the questions. Where, I don't know, if there was a push in the judiciary, I think it would be great to do attorney conducted voir dire. I think, there's nothing more valuable than looking in the eyes of the people who may be on your jury.
Yeah, and asking specific questions targeted to them. I saw that one of the questions that was asked in this case, the defendant's job was a very likable job, or it could be a very disliked job, depending on who, was on the jury. And the court asked them, does anybody here have a particular feeling about the defendant's line of employment? And everybody shook their head no, but you could watch the way that they shook their head no.
Yes.
Yes. I watched one of the jurors, who actually ended up being our forelady. She put her hand on her head and kind of shook her head and said, no, I don't have any opinions that would not allow me to be fair to the defendant. But that tells you there's something more there.
I couldn't agree more.
And with attorney-led voir dire, we would be able to ask questions about that. Well, can you tell us a little bit about, if somebody was the defendant or in a different line of work, would you have any, would they start behind or ahead if this was the case? And we didn't get to do that. But ultimately, it ended up being a very good outcome for our client. I thought it was really, really interesting, and it never gets old, is how much you learn about your client through the process.
Absolutely.
When you're in litigation, which is not trial, you spend a year or two getting a case ready, and you take depositions and you read stuff, but you're working on other cases at the same time. It's amazing how just in that week or two, you really get to know the clients. So you want to talk a little bit about the clients and what it was like to get to know Mr. Shohan?
Yes, I think the Shohan family is absolutely incredible. Obviously, we both got very close with them in the weeks leading up to trial, and I couldn't agree more. I think when you are working on multiple cases, you're only one person, so you only have so much time to dedicate to each client in a given day.
Yeah.
But when you have trial, it is an all hands on deck effort, and you really push the client that you're going to go to trial with to the forefront. And I think getting to spend hours upon hours with them, I mean, truly, they were at our office probably every other day. Preparing with us and getting to know them as people and getting to hear about their son's wedding in India and about their grandbaby. And it really humanizes the trial. I mean, trial, as attorneys, I think we look at things as more black and white, or we have to look at the law. It has to be, all about justice. But when you get to really sit with your clients, it humanizes that aspect. You're like, oh my gosh, this could be like just like my friend, my neighbor, a family member, and it makes you want to do, especially when they're a good client, the best job that you can do. You want them to be happy.
Yes.
And as an attorney, it really tugs on your heartstrings. I think it makes you a better attorney because you have something to work for. You're like, oh, this amazing family was done wrong. What can I do to help them?
And they're counting on you, and they're looking for your guidance about whether to agree to settle a case or go to trial and what that risk is. And they're sitting there, and it's so nerve-wracking for them because they've never been through this process before and probably will never go through it again.
And I remember when, obviously when the jury's about to read out the verdict, your heart beats so fast. And because you want a good outcome for your client. You're like, I've done everything I can to do the best job possible. What's it going to be?
Mm-hmm.
How are they going to decide? And so obviously when you get a good verdict, that was just the most incredible feeling, knowing that they were happy with our result and that we were happy with our result.
And there's going to be times where you don't win, but when you do win and you get a good result for your client and you see their relief that they say, you know what, the jury listened, they understood what I've been trying to say for all these years about how this has affected me in my life, it's just so powerful to see. And
it's really powerful. And I think to your point, Brendan, there are so many attorneys, whether right or wrong, right? It's so much easier to settle a case.
Yes.
Going to trial is, a lot of attorneys, I think, first of all, it's scary. It's nerve-wracking, right? You don't know what the outcome is going to be. You can't give your client a certain outcome of, this is exactly what's going to happen. So it's kind of, in a sense, the Wild West. But I think it's better because, we don't settle cases. Like, if we think that we can get more money, we're going to do everything that we can to get our client more money.
Yes.
And if that means going to trial and doing a jam-up, amazing job for them, then that's what we're going to do. And so to me, it was so nice to see this, from start to finish and be able to do a good job for our client.
Yeah, it's so rewarding to get to do that. And you're right. There's a lot of lawyers these days that are just not going to trial. And they say something like 99% of cases settle. And normally that 1% that does go to trial, it goes to trial because either somebody doesn't understand the value of the case, or maybe it's just a really not good case. And so those are going to trial. But I think that there's a much higher percentage that should be going to trial.
I agree.
I think that there's a lot of cases out there that people are not getting the right value for, and that people are, put off by going to trial. Clients may be put off. Lawyers may not feel comfortable going to trial to try to get what their client actually deserves. And so I'm proud to be a part of a law firm with lawyers like yourself who want to do that, who want to make sure that they get the best result that they can for their client. And ultimately, I didn't go to law school to sit behind a desk and answer the phone. When I closed my eyes and I was in law school, I wanted to stand up in court.
Yeah.
I wanted to do something that mattered for people, and so I enjoy it.
Yeah. Well, it's so funny that you say that, Brendan, because my law school experience, I think, was so different. I never imagined myself going up in trial. I knew I didn't want to sit behind a desk, and I knew I loved people and I loved interacting with clients, but I didn't really see myself ever as a trial attorney. But once you do it once and you get up there and you see that you've done a good job, it makes you want to do it again, right? It's like,
Yeah.
okay, yeah, like I've done this. I've had my first rodeo, and now I can do it again, and it was actually pretty fun, and I enjoyed the process and experience. So even those attorneys who didn't close their eyes and dream about it, I think can still, if someone is out there and they're hesitant of whether or not they should try to go to trial, or that maybe they're on the fence of settling something, I would say go for it. Go to trial and see the outcome, because it might surprise you.
It may surprise you. And if you're not ready to go to trial, but you want to go to trial, give somebody like Dixie or us a call, and we'll try to help in any way we can. I think one of the coolest things about this trial with you was watching your direct examination of Mrs. Chauhan. You had gotten to know her so well by your prep sessions, and when she first came in, she was very reserved.
So nervous.
And she was very nervous, and she didn't really want to open up about what happened and how this injury affected her husband. She didn't really talk to me a lot, but you kind of broke down that wall with her, and I think she ended up being our most important witness in the case.
Yeah, I agree. And I think as a young attorney, especially, you are also nervous when you go to trial, and you don't want to tell that to your client, because obviously they're putting their full faith and trust in you, and you want to, put off this front that you're going to do a good job, which you will.
Yeah.
But that doesn't stop the nerves from coming. But it almost made me more comforted knowing that I knew more about the legal system, obviously, than Mrs. Chauhan did, and so knowing how nervous she was to get up there, I didn't want her to feel nervous, so someone had to step up, and it had to be me.
Yeah.
And so I think having her on the stand, I was like, it's okay. You don't have to be nervous. I'm going to ask you these questions. And also, to your point, Brendan, you made sure, right, that we practiced with them repeatedly over and over and over. And you said, direct examination is very important, or even cross-examination. What are some questions that you may anticipate them asking?
Mm-hmm.
And so I think, again, you can never, prep is very, very important in any kind of trial. And you made sure that we prepped every single day, and even as much as so is to go to the mock courtroom.
Yeah.
Right, and have them practice.
And I think that's a great tip for lawyers out there who are just getting started or who are preparing for their first trial, is to, go to the courtroom, particularly if you can get into the courtroom that you're going to use that day. We asked the judge.
That was invaluable, by the way.
Yes, we asked the judge as soon as they set the case for trial, and we're up on the list, what's called the roster list. When we start getting near the top, we asked the judge, hey, which courtroom are we going to be in? And so Dixie and I, we went to the courtroom. We looked around. We looked at the technology. We let our clients see, hey, this is where you're going to sit. This is what happens when we call you to the stand. This is where the jury's going to be. And then we practice. And we were lucky enough to be able to use a friend of ours, Kenny Berger's office, who actually has a mock courtroom in the office. And we used that one night to prepare. And I thought that was very much invaluable.
Very helpful.
Our clients, when they ultimately did take the stand, I think they were a lot more comfortable.
Absolutely. I could not agree more. I think that they were more familiar with it, especially with the setup of the courtroom, like you had said.
Yeah.
I think having Mrs. Chauhan know where she's going to sit, and even as much as where we're going to stand, where can she look? Where should she look? If she gets nervous, can she look at me? And I really think that helped her tremendously. And so I think to your point, it really is all about the law firm, who you pick, who's going to go to those lengths to make sure you get the result that you want.
Yep. The more comfortable you can make your client, the less things you make them worry about. If they're coming into a foreign location and they've never been there before, and there's a judge and he's wearing robes and they don't know where to sit, all of that is going to create chaos and anxiety. And so it's all about preparation, like you said. So another thing that I thought we could talk about is opposing counsel. I thought we had just a very, very nice and cordial professional opposing counsel on this case. And I thought that showed, that you can really work on a case. You can disagree wholeheartedly with the other side about probably everything to do with the case. And you can lose some important motions. But at the end of the day, we both put up our case. Whether we won or lost, I thought that it was a very professional time. And this lawyer on the other side, he shook our hands after, and we shook his hand, and we all ended up at the same place for dinner. So if you want to talk a little bit about that and the professionalism of some of the trial lawyers in this state, I think that would be good for our audience.
Sure. And I was always told when I was in law school that you will eventually get to a point in your career where you will be surrounded by other people that you went to law school with. And sure enough, Max Safarian, who I'd gone to law school with, was, opposing counsel.
Yeah.
And so he was second chair in that trial. And so that was great to see him again and just have a familiar face. Even though we're on opposite sides of the playing field, doesn't mean that we can't be cordial and we can't be friendly with one another. And I think that's why the South Carolina bar is so special, because it is pretty small. And so the chances of you knowing someone else are great. And even David Overstreet, like you had said, he is phenomenal. I really can't say enough good things about him.
Yeah.
I think as a young attorney, you can learn not only so much from the people that you work with, but also the people that you are against that are just really great attorneys. And I think I learned a lot from him. And I will say, Brendan, you said to be prepared if someone objected during my opening.
Yes.
And so I made sure in every aspect of my opening, I knew where I could pick back up if someone objected. And sure enough, David Overstreet did object in my opening.
Yes, just once. And I think he felt bad doing it, but you immediately picked up where you left off and kept rolling. And he came up afterwards. I don't know if you knew this. Right after you had finished your opening, and said, "Wow, that was really good." So everybody was thoroughly impressed with your opening statement, as well as just your preparation and acumen throughout the trial. So
I
that
appreciate that.
That was great.
Yeah. Well, and even I feel like, Brendan, we've been talking so much about me, but we haven't talked as much about you and even your closing. I mean, I personally think the closing is one of the hardest parts, if not the hardest part of a trial. Because again, as we were talking about with preparation for the trial, you never know how it's going to go, right?
Correct.
Everything is kind of up in the air. But the closing is the most important, because it's the last piece of information the jury will keep with them before they go into deliberations.
Yep.
And it is also one of the hardest things. It's also one of the hardest things to prepare for, right? It's one of the hardest things that you prepare for, because you don't know how the trial is going to go. And so I personally think, yes, I may have done a good job with the opening, but it's much easier, I think, than the closing. So do you want to talk about how your thought process is? No one heard your closing until it happened live. And it was really good. So, I mean, kudos to you for doing that. I mean, I remember sitting in my seat and thinking, oh, yeah, we're going to win. We're going to win this. It was
well, that's
really
great.
good.
I wasn't sure if you thought I had a closing for a while.
Yeah. Well, we didn't. I was like, well, I think Brendan's going to get up there and say whatever he wants, but it's always good, so, right? Which makes you a good attorney.
So, the way that I look at a closing is, and it depends on when the closing happens. If you have a real long trial that's happening over several weeks or over a week, you have some time at the end of each day to go through and jot down some notes about what witnesses said, because they're never going to say the exact same thing that they said in their deposition, which goes to what you're saying is, hey, everything's up in the air. We think that the trial was going to happen this way, but it never does. There's always twists and turns. So the longer I think that you have as the trial goes, I think you can prepare more of a closing. But in this case, because it was relatively short, just 2 days between picking a jury and closing argument, there's not a lot of time there to get ready. And when the judge says, okay, we're just going to go straight to closing, there's not much time. So what I did, and I learned a lot from some great lawyers, and I'm still learning a lot from some great lawyers, is I have kind of my sketch. I kind of have a playbook of things I like to talk about. I think it's really important in a trial, no matter how simple or how complex, that you go through certain things. You thank the jury. You talk about the burden of proof. You show them and talk about the jury charges that they're gonna see, because those are the rules. And it's like, it's way more important than baseball, but it's similar to baseball in that there are rules. And the jury wants to know what those rules are, because that's what they're supposed to follow. Those are coming from the court. And they've never been a jury before, so they don't understand what that is. So if you can be the person who teaches them, that they trust, and then walk them through how those rules apply to your case, and then ultimately why this case is important, and humanizing your client and getting them to believe in your client and everything that they've gone through, I don't think that there's a one right way to do it or wrong ways to do it, but I think that if you just have those kind of main ideas in, and you can kind of plug in the facts where you need to. And I think most importantly is just staying flexible, listening to what the other lawyer says. Listen to what they say in their opening, listen to what the witnesses say, and listen to what they didn't say. And if you can incorporate that, something that happened during the trial, then the jury says, oh, yeah, I do remember that. I was there. So in our case, our client had suffered a shoulder injury. And one of the things he did is that he actually showed the jury how his shoulder had been impacted. And I didn't notice it, but his shoulder actually popped when he lifted it up.
Cinematic.
It was very
Yes,
cinematic.
It was cinematic.
And in closing, I reminded the jury of that, and we got a lot of head nods. Everybody had been paying attention. Everybody saw that. So I thought that was a good example of how being flexible, staying on top of things, knowing what important things happen, and then addressing them. And then also addressing your weak points.
Absolutely.
Yeah.
And Brendan, one of the things that you mentioned that I couldn't agree with more is that you'd referenced that it's almost like, the rules, you have to explain it as if it's a sport, like maybe it's baseball.
Yeah.
My brother is a coach for football and baseball. And I guess I always grew up seeing him coach and seeing the difference. You have to go through so many strategies in your head. If this person's on first base or second base, how's that play how's it gonna play out?
Yeah.
Well, being a trial attorney is really not much different. I mean, truly, you don't know how the game is going to go.
Yep.
You don't know how the trial is going to go. And it is your job as the coach, right, of your team to make sure it goes smoothly. And so I think in your closing, as you were saying, you have to take all these parts and pieces. What happened? What plays do we have left in the playbook? What else can I say to convince the jury, that we're on the right side of justice?
Yep. And what do I think the other side's going to say after I come
yeah.
up? And if you can head that off, if you can tell them why, even if you believe everything that the defendant said, why you still win, then you're in a good place. So I think it was a great experience. Another thing I really enjoyed was getting to know you better. We work together, but it's not the same as where if you're spending 2 weeks with somebody every single day and you're working on something as a team, trying to move it forward, trying to get something done, you gain a connection with somebody. So we got to know each other more personally. Our paralegal Tanner was instrumental in us working on this case, so we got to know him better. I just thought it was a great experience for me.
Great experience. And I think like you were saying, you learn so much about people and you learn what their strengths and weaknesses are. Like I have certain weaknesses, but it's picked up by another player, you or Tanner, and I think that's the beauty of working with people that you not only enjoy working with, but, working with other really good attorneys is because if you might have a weakness in one area, well, believe me, someone else in the firm is going to have a strength in that area.
Yeah.
And so you're never short-staffed in any means by when it comes to something that you need, whether it's trial prep or anything with our firm, which was why I enjoy working there so much.
Yeah, it's so great because I have certain things that I like to do, certain things that I'm better at than other things, but we have people who can do everything. So whether it's a last-minute brief that needs to be written or tweaks to jury charges or coming up with new ideas for closing arguments, those are all things we can do.
And to your point, Brendan, I think you are so good on your feet, which is why I think you're great at the closing. I mean, I thought it was so good. Whereas I really enjoy writing and researching, and so that's why the briefs, the pretrial briefs, they were really important to me. Winning our summary judgment motion before the trial.
Very important.
That was really important. And when the judge asks about a certain case, I know that. So again, it's all about your strengths and weaknesses and how to balance each other out.
And you got to have the whole package. You got to have somebody for everything. No one person is going to have all of the skills to make your team be an A+ team. So we're lucky that we have that. And then we get to bounce ideas off of so many other great people as we're getting ready. One thing, trying to circle back to your opening, but I loved your analogy of if you break it, you buy it. And you came up with that, and I was thinking about that the other day, and it's just a great analogy because everybody gets it. And when you think of an analogy, you want something that is everybody gets, that nobody is going to say, oh, I've never heard that before. So I'll tell you a quick story, and they may cut this out, but I was in law school, and I was in mock trial, and you may laugh at me, but I had never heard the phrase, when you hear hoofs, think horses, not zebras. Okay? I'd never heard that
I've
before.
never heard of that.
It makes sense, right? It
Okay.
makes sense. Okay, you're
Yeah.
going to, horses,
Most
not
common.
zebras, right? Horses are more common. But I didn't think it was a very good analogy. And somebody wanted to use that in their closing argument. And it's fine, it works, but it doesn't have the same effect as you break it, you buy it. Everybody knows that.
Yeah.
If you're going to do a job, do it right.
Right.
Everybody knows that. So I think that when you're picking those things that you want to talk to a jury about, when you're framing your case, you want to pick those truisms that nobody can argue with. Everyone's heard it before, from their grandparents to their parents to their teachers.
Well, and to your point, Brendan, too, I think you have to have an attorney that's really passionate about their case.
Yeah.
Because I didn't think about that on the spot, right? I spent so much time,
Yeah.
whether it was at home, laying down in the bed, or in the shower, eating dinner, thinking about this case. It really consumes your life for a little bit, which I think does make you a better attorney.
Yes.
If you're thinking about one topic over and over and over again. And so I think it was on the eve of trial when I came up with that saying.
Yeah.
We had gone back and forth about different things to say, and so I said, I think this is it. I think you break it, you buy it is a great analogy, and I think that's what we should use. But a good attorney, I think, spends a lot of time thinking about their case.
Constantly.
Yeah, constantly. And I think that's why your closing was so good, is because I knew you were constantly thinking about it. Even though no one heard it, I knew you were constantly thinking about it the entire time. So.
Well, I offered to let you hear it, just so
Yeah.
we're clear. I think I made overtures and,
Yeah,
and
but we
said,
knew.
hey, if
Yeah.
anybody wants to, and I just kind of said, I'm still working on it. I'm still working on it.
But Tanner and I knew you had it, so
well,
we weren't worried. So.
I appreciate y'all.
Yeah.
Well, is there anything else you want to talk about for this session? Is there something that did you use AI at all in getting ready for this trial? Was that helpful, or?
I did use, I think, AI probably in some of the briefing, and I say that in a very broad sense, right? I mean, just some generic help and asking, if I were to say this and the defense were to say this, what would the outcome be? And that's why I think AI can be a really good source, right? You don't rely on it completely and entirely, but you can use it to kind of see what the competition's going to say. I think AI can be your competition, and you can say, what are they going to say? And it'll give you some feedback that I think is maybe some angles I didn't think about. And for my opening, I for sure had ran it through AI and said, tell me, how do you feel about this? Is there anything I can improve upon? Is the verbiage okay? And so I think AI is a great resource.
Yeah. I agree. And just to be clear, we don't use AI to ever cite cases or things like that, but running the idea of arguments through, what are some good analogies? How can we clean up sections? What does it think of our opening versus closing, or the facts of cases? It really gives you a lot of ideas that, some of them you've thought of already, and some of them you haven't. And then you got to take those and then kind of turn them into your own, do your own voice, and then use them along with your own ideas. But I thought it was helpful. I had used it. I'm starting to use it more and more in my practice to speed things up, and I think it helps. Like even direct examinations, I can do a first draft in AI and then start working on it from there.
One thing I actually picked up from another partner, obviously Will, you know Will, but for the people who are listening that maybe don't know Will, he's another partner at our firm. And Will actually, the other day, had sent around an email. We're all working on a case together. I realize this is a bit off topic from our trial, but he had done a deposition, and he ended up sending a summary of what the deposition was. Obviously, he didn't have the transcript. It was right after he had taken it. And so I emailed, I said, Will, how did you do this? And he said, well, I dictated it. I pressed the button where you can record yourself in ChatGPT, and I just spoke into it as if it was a dictaphone. And I said, these are the highlights of the deposition. Can you turn this into a memo? These are the admissions that I got that I thought were helpful. These are the things that weren't said. And ChatGPT spit out a very, very concise memo. And so actually in the same case, I just took a deposition yesterday. And I did the same thing. I said, these are all the points that we hit on. These are the cases where this doctor has been involved in different legal malpractice cases himself. And it was super helpful. I mean, the memo it was very, very concise. All the other attorneys could read it who were on the case with me, could read it, and I didn't have to spend 30 minutes typing it up.
And it only takes a few minutes after you get done meeting with a client or taking a deposition to do that. And to have that in the file is just so easy to just grab it and know what was said and what was important. Before we go, are there particular cases that you really enjoy working on right now that you want to tell people, and if they need help or want to reach out to you about that you think are interesting and fun, you want to do more of?
Sure. Personally, Brendan, I know the two of us work on. You've pulled me in on some major fatality car wreck cases, which I think are very interesting.
Yeah.
And besides that, just some 18-wheeler car crashes that have happened, which I think are very interesting as well. I like the facts a bit more. I mean, I do a lot of nursing home negligence. I think that's very interesting. Obviously, I think people care for some reason a lot more about babies than they do about old people, which I don't really understand, because I think when you're coming into this life, it's just as important as when you're going out.
Yeah.
And so I think having care for our elders is significantly important, especially, I have grandparents who are getting older, and I would want them to receive adequate care. And if they didn't receive that care, certainly that someone would be held accountable for it. And so I really enjoy my nursing home cases. I tend to think that the clients that I help, whether that's, oftentimes the parent or the children of the elderly individuals who are really great, and, they just want the best care for their parents.
Yeah.
So I tend to really enjoy those cases as well. And then we have a sprinkle of we really do kind of a plethora of just different cases. So I enjoy working on each one of them.
Wonderful. Yeah, with nursing home cases, I used to do a lot more of them. Just the idea of, our golden years. You always think as we're working, you're in your 30s, you're in your 40s, you're in your 50s, you're working, and you're thinking to yourself, okay, one day I'm going to get to my golden years. And that's what we were all told. We're going to walk on the beach with our loved ones or our husband or wife, and then as your golden years go, you get injured or you have some sickness that happens and you end up in a nursing home. And those last days, are definitely just as important or more important as our first days, because now you're at a time limit. You know that you're only going to be on this earth so much longer, and we should be making sure that these people receive the best care, that their children know that their parents are being loved on and cherished. But too often what we see is we see companies that don't want to hire enough staff, that cut staff, that hire people who are unwilling to do the job that they're being paid to do, to take care of people. And they're not just people. They're people's parents, they're people's brothers and sisters, and they're people's children. And so it's an important area of work, as well as tractor-trailer crash cases. Those are very unique in terms of the regulations that apply to them, some of the accident reconstruction that can go in, and then a lot of times that can dovetail, or it can end up with a product liability case, whether there's a fire, and that's something that we do. And
those are always very fascinating from a legal perspective with the case law. I think products liability cases are just extremely fascinating as well.
Yeah, I like them a lot, and I am continuing to do more and more of them as my time gets squished down. I don't have as much time to do everything I'd like to do, but that is an area that I really enjoy.
Well, we stay busy because we're good at what we do. So.
That's right. Yeah. So, well, thank you, Dixie. I've really enjoyed working with you at the firm, and I think you're doing fantastic. And I know that the Shohans are very thankful, and hopefully they'll be in the office soon.
Yes, they said that they're going to come back and visit us. So, and I know that they will. I think they're bringing us some presents back from India.
Good.
So yeah,
I'm excited.
It's great. She texts me all the time. So,
does she?
Yeah.
No way.
Yeah,
That's
we
wonderful.
Keep in touch, so.
Yeah, I talked to Darman last week. I think they were still in India.
Mm-hmm.
I bet the wedding was.
Oh, phenomenal!
Phenomenal.
Yeah.
If it's anything like the other wedding.
Oh, yeah. It looked like royalty, so I'm very jealous they got to go. Maybe one day I'll get to go over there, so it's cool.
Awesome. All right. Well, thank you, Dixie.
Thank you.